Good morning. Good morning. Hold on, I've got to change. Sorry, I was just recording the podcast and now I have to change all my settings. Super prepared this morning. Good morning. Good morning. Happy Tuesday. It is Tuesday, June 3rd. It is Lucy's birthday. She is 6 years old today. So everybody wish Lucy a happy 6th birthday. Our little buddy. Our little buddy. It is day 26. Day 26. Right? Yep. Sure is. It is day 26. I am burning the candle at both ends. So if I seem a little off, I'm just talking about, I'm recording right now, talking about one thing. And then I have to within 20 seconds, jump over here and switch gears. So my brain is working a little bit slower than, so it's fine. Everything's fine. I love all the birthday wishes. She doesn't know how to read yet. We're going to work on that for before birthday 7, but I will tell her, your friends are wishing you happy birthday. They're all wishing you happy birthday. Yeah, you're bad, but they don't know that. They're wishing you happy birthday. For anybody who didn't see it, I was on Court TV last night with Vinnie Politan, and we went over some Karen Reed stuff, and I gave my opinions on a few different things. So if you didn't get to see that, it was on Vinnie Politan Investigates. It was live on Court TV last night. I think they released the video on YouTube the following day, so it should be out sometime today. So we got to do that. That's my opinion. Yes. I need to make sure that I have my audio swapped over. I had to change. Let's see, speakers, headphones. Let me see. We might have to do headphones today because y'all hear static? I don't. Some of you are hearing static and some of you aren't. I don't hear static. I'm not sure why. Tech Problem Tuesday. No static? Okay. All right, well. Good morning. Good morning. Just every once in a while. Yeah, I don't know. Tech Problem Tuesday. It'll probably get worse. I don't know. We're just going to go with it. Let me get our screen shared so that we can get oops, wrong screen. That's me recording. Wrong screen. I might have to use headphones today because all my settings are changed because of recording and then being on Vinnie Politan last night. Because of being on Vinnie Politan last night, I had to change a bunch of stuff, and then recording all morning. I woke up early to record, and so everything is swapped over. So we might have whatever. We're just going to do the best we can. We're just going to go with it. It's Lucy's birthday. Lucy's birthday. She's 6 years old. She's very grown. All right, so we'll see if this works. If not, then we're just going to figure it out as we go. We have day 26. We have a few witnesses that we are expecting to hear from today. Lucky, the snowplow driver, is one of them. That is one of them. You get to sing happy birthday. I love to sing. I can sing, like, as in I am physically capable of the action. It just sounds terrible when I do it. So I will sing to her when I am muted and I don't have to torture all of you. Let's see. Lucky, the snowplow driver, is one of the witnesses we expect to see. We have, where's my other sheet that I just had where I had all this pulled up? We also have the Dighton officer, Barros, I think, who is supposed to be testifying. There was one other one. Who was it? Who was the other one? Who, if anyone? Oh, Kolakithis. Karina Kolakithis. That was the other one. So we're expecting to hear from her today too. So, or long guys are back. They're doing the weed eating today. They come on Mondays and Tuesdays. On Mondays, they do like the area back here. And then on Tuesdays, they do it right here. So Monday and Tuesday mornings, there's always like a buzz in my ear. Karina Kolakithis is the other one who is that we're planning on hearing from. Nicholas Barros is the officer from Dighton who went to go see the car when they were putting it on the tow truck from Karen's parents' house to go to the Sallyport. And he's the one, when he testified in the last trial, he said that he saw the taillight and he said it was like cracked, but not completely broken. So he's going to be called to the stand. And then Karina Kolakithis was at Waterfall that night. She's the one who said that they talked to, her and Karen Reed had talked that night. And I guess if I'm trying to remember the details of exactly what she said, Karen had told her that they had some issues or whatever. And, they were, she was frustrated because she felt like John's family wasn't helping enough with the kids and it all fell back on John. And she wanted to spend some more time with John. They didn't really get, much alone time together. And she was, I don't know if y'all can hear that yard guy. She didn't know if, or she had told her, Karen had told her that they were going to be planning some things in the future or whatever, that they had, she was looking forward to things that they're planning in the future now because they were going to make some time to do some things and we're planning some trips. I think that will, one of the things that they're trying to say, the prosecution's trying to say, is that John was planning on leaving her or tried to leave her or whatever. And so Kolakithis saying, yeah, they were planning trips together and stuff, kind of goes against that. So maybe that's something that we'll hear from her again. And then, of course, Lucky Lawford is the snowplow driver. So that's who we've got so far that we know is coming. I don't know if there's a link yet. I don't know if they've put it out yet. It was on, I don't know what time they put it out the next day. It was on TV last night at 9, but I don't know when they actually put it out. But It was me and DePietro, which is ironic since I was just saying last week I thought he was a parody account, and it was me and DePietro that were on there for our segment. Oh, it was on this morning too? I didn't know that. Did she testify last trial that Jen was telling Karen, come with me, I have a surprise? I think she's the one.
All persons having anything
Can y'all hear court?
the Honorable Beverly Canoni,
Can you hear court?
Superior Court, hold an indictment within and for the County of Norfolk. Grenier, give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. Okay. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning, jurors.
I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday?
I did.
Does Dr. Russell in the back there? Mr. Brennan, you can set up if you want to.
What's he setting up for? Oh, because he's gonna. Oh, that's right. Ugh. Because he's questioning Dr. Russell.
Doctor, I remind you, you're still under oath. Thank you.
Thank you. Good morning, Dr. Russell.
All right. Here we go. My phone's about to die. I forgot to charge it.
Yeah.
Yes.
Good morning, doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Alessi.
Oh gosh, then all of her opinions
Mr.
are
Alessi, is that gentleman the attorney who asked questions
void.
on direct examination?
Yes.
Okay. And so did Mr. Alessi help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
She stood by
Your
that.
recollection,
She
I'm
said,
happy to show you what
Yes,
you just
please.
testified to. You want to
Yes,
see it again?
yes.
she has said multiple times in medicine, you can't give 100%
By the way,
certainty on
between
anything.
last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Or did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during the
didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I did
order
not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday. No. Not in the car yesterday. No.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver. Yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride home, back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning, other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking you about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony,
Hank's such a
what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
What else did he tell? How did it come up? Hey, by the way, ask
I-
for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
You have any memory issues?
No.
what an
May I
oh
approach?
Yes.
oh
Transcript.
oh uh-uh oh
Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at
Oh.
the feed. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
That looks consistent.
You want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
wow
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date,
Yes,
may I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach.
Objection.
Oh, you
Strike that. Just-
oh you asshole
May I approach?
Yes. What page you want us to?
23.
he's low down scum. This is my opinion.
21st, 2024, Doctor?
June 21st.
He's
Page
disgusting.
23,
He's
line
disgusting.
14.
Everything about him.
Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
He's
I said yes.
disgusting.
Thank you. Have that back?
Yes, you may.
Okay, thank you.
I'm pissed.
When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it,
Sure.
that sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there's some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes,
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you describe methodology, you were asked by attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. Demunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make and nurse practitioners and the like make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the method and the articles that I read. The numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely want to be in this case. You weren't sought out, you sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like to put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for a sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
4?
Yes.
5?
Which did you call 4? 4, 5, 6, maybe.
Okay. So as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe so,
course.
but I'd have to see the
Do
transcript.
you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
She's had to do this 3 different times.
So do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion,
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this,
She's explained this before. He's
consider
trying
the
to.
methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
No.
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
But when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No,
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
She said that all
I disagree
along.
with that. I believe that the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder,
Mhm.
right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, they're at the end of the paw. They come to a point. And by the way, the paws can open and close. So the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
I haven't had enough sleep to say anything nice right now, so I'm just going to keep my mouth shut for a little bit. He's mischaracterizing a lot of what she said. She specifically said that it is pattern recognition. You look at the entire pattern.
Yes.
That's like saying, oh, he got hit by a car and the taillight calls that. Which part of the taillight?
When you first testified on June 18th, doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18, 2024 testimony. On page 37, line 7, the questions begin. And you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay.
I just want to.
Thank you. That was your first testimony last year, yes?
Yes.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report?
Yes.
After your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canines.
Correct.
And the smaller ones are incisors.
Correct.
There's 6
Oh,
incisors
incisors?
and a healthy dog on the top and bottom between the canines.
Correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth, and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused.
Okay, a little bit of context here. If you didn't see the first 3 times that we've gone over this in depth with her, when she originally came in, she had her opinions, and basically she's looking at it as like, okay, this is, a pattern recognition. So I'm looking at it as an overall pattern. Teeth and claw marks can look similar. I'm looking at this as an overall pattern, but I can, I can tell you that there are some that I think are teeth. There's some that look more like claw marks, but they're all very similar. So they questioned her really hard on that. So she was like, so she said when she came back, she was like, okay, well, I did what any good doctor would do. If my opinions are being challenged, I went and, reevaluated it, spent some more time looking, compared, whatever, did some more research, whatever. And I went from having my opinion being a little bit more like vague or open to looking deeper into it to check myself, because I'm a doctor and that's what we do. That's what a good doctor does. So she said she went and looked at it closer, did some more examination and stuff. And then she came up with more specific, like ideas on, I guess ideas isn't the right one, like more specific determinations on which one, instead of like being a little bit more open with it, since they were challenging that. She was like, okay, well, if you're going to challenge that, then yeah, let me look into it more. And then she narrowed it down and she made decisions on which one she thinks is which, but she still said it is pattern recognition and they are still very similar. So I can look at this and say, this is what I think it is, but that doesn't mean that it can't be this. This is what I think it is and why. But does that mean it's not this? No. So he's trying to make this into like her being flaky or changing her mind.
These wounds before you filed the report ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged. And each time I reviewed the case, I became more certain that these were from canine teeth.
So
And actually, there's other marks there, but these are from teeth.
you say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Top,
Canines are some of the teeth.
upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
Were you alive?
Do you remember that conversation? You said that the point of entry would be the bigger circle pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that
Don't
at
remember
all.
that conversation
No.
we had? Okay. And so inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound
Yes.
up there, closest, I agree. Yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me. Yep. Four,
Mhm.
same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for five and same for six.
That's
Correct.
why it's pattern recognition.
When you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number two, what caused this wound, Dr. Russell?
Number two, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny pinpoint almost lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through
The
each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number two, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these two scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these not exact, these two linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
I'm going to object to the worded use
So-
that's been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can
approach?
you just hold 1 second? Could you please turn the fan off? Jurors, is it okay if we turn the fan off so we can hear better? Thank you very much, Officer Dewan.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth. Weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay.
Ugh.
I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder. And then the sentence, but I'm not sure on the second set. So this is the set that's just above the elbow. I said, I'm not sure.
And then, sorry,
Oh, go ahead.
are you done?
Oh. Oh, yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter of factly, not with any qualification. Your claim at the last hearing is this was some teeth.
That's what I believe.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You were
Yes.
asked, what do you think? And you didn't say without 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two are caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell.
Mm-hmm.
A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly
arm?
what I'm asking. It's a question I've asked before.
Oh my
When
gosh.
you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes, and coincidentally, every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be,
Well, do you have the
Specific.
opinion today? And I'm getting the transcript.
Oh my gosh.
thank
Do you
you.
have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
So I'm over him.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it?
Again,
Objection, Your Honor.
So there was a question with that, so I'm going to let that.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I did
measure
not.
them? Did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper or report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes. I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really
when-
think?
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case,
Yes. Yes.
I didn't have a lot of information. That's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident and
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I
Yeah.
am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors,
Have you
yes.
studied that before you gave this
Studied.
opinion? Yes. Did you go and actually look at the photos, do any measurements?
Have
before
you worn
gave
blue
this
paint?
opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear tail light or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And
photographs.
when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I
Respectfully.
have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling
Fastly.
on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I
Videos?
saw a picture.
Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass
Have you
in the
looked at-
picture.
have you
That's
ever
not
looked
from
at
that.
Mr. O'Keefe's
No,
pants?
she's
Did
wrong
you
on
see
that.
Dirt or grass stains on the back of them.
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at
I
the
don't.
pants?
I don't know if I looked at the pants.
So when
To
you
tell
say
you
you
the
didn't
truth.
see any evidence, are you saying you didn't look or you looked and you don't?
He's badgering
see
her.
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pant photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion
Oh my
about
gosh.
something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
we'll come to sidelines.
It is an attorney's job to poke holes in the other case. And I get that. I understand that. The level of disrespect is where I have the problem. I don't have an issue with going through and trying to poke holes in something. The problem for me comes with how disrespectful he is, number one. And number two, how he misrepresents things intentionally to try to make it look like something that it's not. And that's where I have the problem with it. He spins things in a way that misrepresents it. It is so... It's so frustrating to watch. I don't know how it will come across to the jurors. I know how I feel about it. Also, I don't like him anyway, so. So at sidebar, it says Alessi is loud. He's using hand motions. He's leaning down toward Canoni as she leans down and is now pointing at Brennan. What are we thinking? How are we feeling? I just feel like there's a difference in trying to poke holes in the defense and what he's doing. What he's doing is different. I haven't had enough sleep to be able to have anything positive to say about this.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
Hold on. Hold on. Hold on. Did Hank just Uno flip reverse this and now we're going with branches? I'm going to say that we misunderstood that. I'm going to assume.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are the instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries. Correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
Yes. Many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes. I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you con-
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Can I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off, correct?
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware, I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat, there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your study in the foundation of your opinion that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes,
Early morning hours.
yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having a trouble
Okay,
understanding the
it's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes,
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle. Yes?
that's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes,
And you learned that her right rear taillight was broken and missing pieces. Yes?
yes,
Did you want to know if there was any evidence depicting when that taillight was broken? And considering this conclusion,
yes.
did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, a car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Miss Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and timing?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be, I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we
car,
have
the vehicle parked, yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No,
You had, as a police officer, when you're excluding the source, and in this case, you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision. Do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
as a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to
As a
be
police
the,
officer in an investigation, that's
um,
not what this
the
is.
veracity of the
Uh,
witness.
I'm getting
Have you listened to the statements of the defendant herself in this case
I'm getting
regarding
really annoyed.
potential impact?
No, what do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about, did I hit him or something of that? I don't, what do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact, a collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They they act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that
She was-
situation.
No. Does it happen a year later when
She was
you go
explaining her
and speak to
thoughts in that
documentarians and
moment.
be interviewed? Is that the same kind of condition you see
Ugh.
a year
You know,
later, year and a half later?
He's misrepresenting
Grief
this.
reaction can last years. It usually is very brief, but it can last years.
Now, when
This is exactly why she needs to ask for transcripts, because he's misrepresenting that. Karen Reed was not on Dateline like telling the lady like, oh, I wonder if I hit him and all that. She was explaining why she said that in that moment. She's literally explaining her acute grief reaction in that moment. And this is exactly why he's not trustworthy and why I can't stand him, because he's literally misrepresenting this right now. And this is why she is right to ask for her transcripts, because he misrepresents everything.
looked at the clothes in this
Snake.
case,
I can't
Mr.
stand
O'Keefe's
him.
clothes.
I'm going to mute myself. I'm not.
You are aware that those clothes were swabbed for DNA traces, aren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
I needed to get Lucy because I needed my emotional support pup for a minute because keep having to mute myself because I can't say anything nice. So we're going to get Lucy on her birthday to give us some, oh, look at that leg. I got the spot, huh? To give us some emotional support so that we can start being nicer. Because I don't have anything nice or positive to say about Hank Brennan right now. It's your birthday. Say hi to your friends. Say hi to your friends. Say hi. Bad dog. They're telling you happy birthday. They're telling you happy birthday. How would you feel if Lucy liked Brennan? I know she would get rehomed. That'd be a lesson. But I know she doesn't like Brennan. She doesn't like people who behave like that. Juror reactions: yawning, looking down, sitting on hands, writing notes, looking at the Reed family, looking at sidebar, looking around the room, scratching head, leaning on hands, standing. Sick. Yeah, off to the pound with you. I tell her that when she's bad. I emotionally abuse my dog. I'm like, you're going to the pound. Got to keep her on her toes, you know. Rehomed and named Linda. Listen, Linda. That's right. Sorry. I said she. I mean it. You're an it. Listen, Linda. Linda, listen. She doesn't like Brennan. It's fine. We don't have to make it that far. Looking at the fan, looking towards the O'Keefe family, looking at sidebar. I would not judge Lucy. Her job was to analyze wounds, not analyze the entire case, right? Correct. But here's the thing with Brennan. He always throws in all of these other things to make it look like she didn't have enough information or like she wasn't doing her job or like it was incomplete when none of that is factual. Fact schmacks. Who needs those? Right. Lucy is teaching me how to give a bit of grace to Brennan. I'm trying. Alessi is getting worked up again at sidebar. I don't blame him. I feel like Alessi and I are like we're kind of like spreadsheet binder soulmates in a way, but also I feel like because of that, I feel like he gets worked up over some of the same stuff that I do. So I'm not surprised that he's angry at sidebar because I am also angry at sidebar. Because there's just no sense in acting like that.
Than any of us wanted to do while you're sitting here. So we're going to continue what we're doing, but we will give you the morning recess. So let's say about a half an hour or so. Okay.
All rise for the court, please. Close your notebooks. Follow me.
Sorry, I forgot I'm still big. I'm not. Morning recess. What are we thinking? How are we feeling? Court's still in session, though. They're still.
Thank you.
Sam, watch your step coming down. Follow me.
Jurors exiting the courtroom, please be seated.
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Mr. Brennan, can you remove? Oh, okay, it's being removed.
Jackson looks bad, too.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made, that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal, Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Whoa.
Thank you. Mr. Brennan.
She's going to turn it down, but
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated,
it's not accurate, but
rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it. She discounted it. She created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper. It's not unconstitutional. It's not irrelevant. It's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions for yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you, Your Honor.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me.
Yeah.
She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm.
Yeah, it's a swab.
There was no swabbing of the wounds to of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
You have 30 seconds.
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial, it can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12th, 2024 transcript. I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alessi on direct examination. And there are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alessi. Wholly.
All right, thank you. We'll give everybody a half an hour.
All right.
What are we thinking? How are we feeling? Tired, furious, mad. Yeah. All the above. So this just got wild. Okay. Brennan bringing up, first of all, let me pull up the voir dire from December 12th so we can see exactly what was said. Okay. YouTube. He's saying that Brennan had said that they were not going, the prosecution wasn't going to bring up the dog DNA. Okay. In the last trial, Terry Coon from whatever it was, I can't remember what it was. Whatever DNA lab. My mind escapes me what it was called. But she testified and she came in and she said that they had done the DNA swabs of the shirt on John O'Keefe's sleeve. So what she did is she took, it was technically 2 swabs, but it was, and she did them together, which is against protocol. There's a whole podcast thing about. Anyway, she took 2 swabs at the same time and she held them together and she kind of rubbed it around the holes in John O'Keefe's sleeve. Then they tested that for canine DNA and it came back with no canine DNA, but there was pig DNA, which is weird. UCLA. Yes. Thank you. I was like, it's California, but I can't remember what in California, but yes, UCLA. Thank you. So that's the way that they did it. So there were no swabs done of his actual arm injuries. It was only of the one swab that was done around the holes. And she's like, she said there's no video or notations of exactly where she rubbed, swabbed it or whatever. It's just, she said she just did it around the holes, testing for canine DNA, and it came back negative. So, so him saying that there was no DNA on the clothing is another misrepresentation because that's his favorite thing to do. Yeah, we'll do a poll if you think she's going to declare it, but nobody thinks she's going to declare it because she doesn't declare anything for the. She doesn't side with the defense for anything, ever. Oh. Start a poll. Will Bev declare mistrial? And the mistrial with prejudice means that they can't try it again. It means it's denied and it's over, or declared and it's over. All right, so the swabs were never done of the actual arm injuries. They were only done of the, like I said, around the whatever. They had said when they were making their strategies going into this case, the prosecution had said that they were not going to introduce the dog DNA aspect of this. They were not going to call Terry Coon to come testify to that. They were leaving that part out. So Alessi saying, all right, you said that you were leaving that part out, and now you've introduced this, intentionally introduced this idea that, hold on, let me go back to my notes. I was furiously taking notes while they were going through all this. The concept of DNA. So brought it in intentionally. Prosecution didn't bring in Terry Kuhn with the dog DNA. Defense has been meticulous about not mentioning DNA in any fashion, directly or indirectly, with regards to that. Prosecution said that they are on hearing. Alessi says that's not true. The only remedy is mistrial with prejudice. So then Brennan says inquiring of absence of dog DNA is proper and permissible, entitled to explore theories and facades that the defense brings up. So he's saying that the defense brought it up first in that hearing. I want to go back and see exactly what was said. We're off the rails early this morning. Let's see. Let's
Consider
see.
circumstantial evidence as a police.
Oh, that was January 7th. So what he said December is the one that, right? December. I've got to get to it. Hearing resumes. Link in your tab. We got that one.
As a police officer.
And the one before that. Here it is. Okay. Show transcript.
Asking you if you think you're an
Okay, so let's see. I'm pulling it up based on the transcript saying DNA. The first time it's mentioned is Alessi saying expert in toxicology. She's saying she's not a toxicologist.
Expert in
Oops.
toxicology.
I'm not suggesting you're unfamiliar with it or you haven't had experience or some training. I'm asking you if you think you're
Oh, that's
Correct.
Brennan.
In fact, you know very little about DNA, don't you?
I would say that's pretty reasonable, yes.
That's what you
Wait, why is...
sir.
Hold on.
Said.
Yes.
Oh.
Wait, hold on. I'm confused because he said on direct, but hold on. December 12th. When was this one? This is December 12th. DNA.
And it appears that some of the holes that is on the right sleeve of that hood. Well, it's a small.
I don't see anything in the. The very first time DNA comes up on this that I can find on December 12th is Brennan asking about it.
Asking you if you think you're an
Correct.
In fact, you know very little about DNA, don't you?
The other times it's mentioned, it's in comments. So the reason it's a big deal that they're asking about it is because they did not bring in that evidence. That's not evidence that they brought in. So saying it is, okay, we know that Hank misrepresents things, right? He just did it again. We know that. It's part of his whole thing. Bringing something like that up to the jury is very misleading because they haven't heard the evidence about it. So it's like Brennan said, I'm not introducing, they agreed, I'm not introducing this evidence in my case in chief. And now their case in chief is over. This evidence was not presented. So now he's referencing evidence that wasn't presented to the jury, and he's presenting it however he wants to. So now that's very intentional. So now he's making the jury think, oh, well, there was no dog DNA on that. Well, I didn't know that. The reason they didn't know that is because that wasn't brought in. But you can't say that here's this, did you know about this evidence and introduce it to the jury in that way, because they haven't had a chance to actually hear the evidence and hear what's wrong with the evidence. They're only hearing the way that Hank presented it, which is incorrect, because there were no swabs done of his arms. And then the swabs that were done on his clothing, there was the one swab that was actually done, 2 swabs at the same time, which is not protocol, number one. But also, let's say we just took him at his word. If we didn't know this and we just took him at his word, we would think, oh, there was no dog DNA on the clothing. But that's not accurate. That's a piece of evidence that's not actual what the evidence is. What the evidence is that there were swabs done, 2 of them at the same time. We don't know exactly where the swabs were done. She just said that she did them, around some of the tears. They tested the swabs. There are different things that can make it come back, that can prevent you from being able to see it. Like blood is one. The dye in clothing is one. There are things that can make you not be able to see the DNA if it's there, or it can inhibit it from showing up on the test. So his skin was never swabbed. His shirt was swabbed outside of UCLA protocol, and there were inhibitors. So the absence of DNA is not necessarily evidence that there wasn't any there. And Hank knows that. We all know that. We've gone through this with, and when he asked her about that, she even said, she was like, yeah, the absence of DNA is not in and of itself evidence that it's not there. And, she said the reasons why. She's not a DNA expert, which is what Hank was asking her during that, hearing. She's not a DNA expert, sure, but she knows enough about it because she was law enforcement, law enforcement, and she is, a physician. So she knows enough about it to know those things. And I'm not an expert, but I know enough about it to know those things because we've been through so many trials and stuff, and we've gone through this argument for 2 years. So saying in front of the jury this piece of evidence without it having been entered in a way that can give the jury context about what there is actually evidence of is a dirty move. And Alessi is saying you can't unring that bell with the jury. So he's saying the only way to remedy this is by a mistrial, because now the jury isn't going to be able to just disregard that, because now they're going to think that what he said is true. Oh boy. Let me see if I can find dog bite. 5 months ago. Let me see if I can find it in the other one. Oh. Nope, not that. Because that's going to be it's going to be a big issue. I want to see, I'm trying to find the whole gosh, there's so many. I feel like I've been streaming this thing for it's 5 months ago. Let's see, is this one? It's part 3. Link. All right, let me see if I can find it in this one. Oh, of course, there's no transcript on this one. I want to find it so that when they come back, we know exactly what was actually said. I think Bev will deny it because that's what she does. All right, show transcript. I'm just going to go to my channel and do it because everybody else's is too unorganized, and I have mine very organized. I love a good list. DNA.
Look at the forensic.
Okay, it looks like Alessi brought it up when he asked the things that she looked at. And this is December 12th, right? Yeah, this is December 12th. So you look at the photographs of a dog bite and certificate of vaccination. Yes. You look at the forensic DNA testing report by UC Davis Veterinary Genetics Laboratory. Yes. Did you look at UC Davis Genetic Laboratory case report? Yes. So he's going over all the things that she looked at. Did you consider DNA evidence in this case? So he asked if she looked at that report and she said yes.
Let me ask you, did you review the UC Davis Veterinary Genetics DNA report?
Coming to your conclusions. Those injuries were inflicted by a dog. Are you aware of the DNA testing for UC Davis facility? I'm aware. I'm aware that DNA was not found.
I'm aware that DNA was not found.
And
Excuse me, let me clarify that. I'm aware that dog DNA was not found.
and
So she said she was aware that dog DNA was not found. So he's asking her about those. So let's go back and see what his argument is. Dr. Russell testified she considered dog DNA before. So they asked her, so Alessi did ask her about the dog DNA or about the UCLA lab reports. And yes, there was pig DNA. Oh. Hi.
Girl.
I know. I'm spiraling. I'm sitting here looking because now I'm trying to find all of the stuff, like all the things that they just accuse each other of. And I'm like looking at old hearings, like trying to see, who said what when and what we can compare it to and who's madder than who. And
I was just got out of recording 2 deck episodes, and I come upstairs and everyone's like, they're arguing for a mistrial. Like, what is happening?
Yeah.
On a scale of some of them or all of them, how many of your eyelashes will you pull out if you have to sit through a 3rd trial?
I just paid for these eyelashes, so I'm hoping I don't want to have to pull too many out right now, but yes, like all of them. I'm sitting here thinking, and I was just thinking last night, I was like, I wrapped up with Vinnie Politan last night, and I was like, gosh, I'm so tired. I still have to work on the podcast, and I have all this stuff to do. And I was like, we're okay. Trial's almost over. If they call
You jinxed
trial, no, I know. I shouldn't have said anything.
I should all this on you, but
I know. So yeah.
So so they're at their morning recess. Is Bev going to come back and decide, or is Bev going to come back and then call it a day, or do we know?
She's going to have to come back and give an answer because I feel like she is very rarely sides with the defense on big things. And I don't think that she's going to do it. And I could be surprised because she's surprised me before with her rulings, but I don't foresee her doing it, especially with us being so close to the end. I don't know how she's going to handle it though. It's crazy to me because I cannot possibly think of having gone through all of this time since April 1st, because we had jury duty since April 1st and then the trial starting April 22nd. And we are now in June. So I'm like, I can't even.
Did they stop? I didn't see how it unfolded. Did they stop like mid witness, or did they wait until?
Oh yeah. Oh yeah. He objected, and Alessi objected, and they went to sidebar. And so they were arguing about it over sidebar for a minute. And then I'm stalking the courtroom reporters, and they were saying that Alessi was over there and he was getting very animated. And so she sent them to break and then said, I'll hear your arguments. So then they gave their arguments, and like, he was mad, like his face was red, and he was like, this is irreparable.
And he's frustrated.
Oh, yeah.
So he's upset that they brought up the fact that there's no dog DNA because they're not talking about DNA. Why wouldn't they be able to bring it up? I don't get it.
So the thing is, because UCLA Davis they did, Terry Kuhn was there, like dog DNA lab lady, and she came in and testified in the last trial, but they decided that they made a strategic decision not to bring her in during this trial. So neither side was going to introduce that evidence, trying to just streamline everything. So now he's presented his case in chief, did not bring her in to testify about this. And so the jury's heard nothing about dog DNA. So Alessi saying now he has strategically thrown that in there to the jury as if it's, evidence. And the problem is, him saying that there's no dog DNA on there is very misleading because there was no dog DNA detected on the swab that was done, but he can't say that it was from the clothes, and they don't know exactly where they swabbed it. She just said it was, around the holes. There's also inhibitors that can prevent it from showing up on the test. And some of those inhibitors, it did test positive for inhibitors, which means that there could have been some, it just didn't show it. So
and then there was the pig DNA, which could come from dog treats. And
yeah. So it's kind of like, if you're going to present evidence, you have to have it presented in a way that the jury can get the whole story with it. And he didn't do that. And now he's just throwing it in there. And so Alessi's saying, like, now they can't unhear that because now you've presented them with evidence without.
Right. But she'll come back and just be like, disregard.
Mm-hmm. Yeah.
Disregard.
It's crazy.
When is she due back?
They told them at, let's see, we were 1:55 in the street. I mean, it's been like an hour since, 45 minutes since she sent them, and she told them it was going to be 30 minutes. But they finished the actual arguments, I think, around like 2 hours and 10 minutes into the thing. So about half an hour ago. So it should be soon. Oh, it's crazy. It's crazy.
Karen afford a third trial? Like, who's paying for this?
Well, she has sold her house. She has cashed in her 401k, and then she has like fundraisers that they do to, earn money for it. Alessi's pro bono, I believe, and her other attorneys are not working for what their normal fees are. So most of the money is going towards, like experts and expenses, and paying for the attorneys when they come into town for everything, and that kind of stuff. But
you are unmuted.
oh,
Bye.
oh, bye.
Please be seated, court is in session.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Wow.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh, yes, but not right now. They're on their way. All right. Do you have an?
I'll work around it.
Okay.
Work around it.
Your Honor, I would object to being done outside the jury, that it should be done like I've had to do with several witnesses in front of the jury.
Okay, if that's what the defense wants. Are you sure, Mr. Alessi?
Oh, I'm sorry, let me confirm with my. Yeah, okay. I am going to, yes, Your Honor, we are going to.
Oh, dear.
Thank you, Your Honor.
Okay.
You're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Are the lunches here? Are they still over there? How long they are?
Did you start yet, or can you turn?
If they're downstairs on their way up, I don't want to stop them.
I could do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, with subject whatever Your Honor does, based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects Your Honor's scheduling for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they did.
All right, we'll do this now. Okay?
Oh, boy.
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I?
Yes. Can we turn the fan off over here, Tony, please? Thank you.
Dr. Russell, did you ever review and receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with a dog bite?
Yes.
Did you disregard it or agree with it?
I disregard. I disagree with his assessment.
Thank you. Or I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it, and I was not allowed to pursue questioning. So I do not believe, under the standards that's been set in this trial, that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
It's
Because
not.
they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Alessi?
Thank you, Your Honor. My response is this. I'll give 2 quick examples. Dr. Welcher, Trooper Ball, Dr. Scordy Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Scordy Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark.
Okay. All right, thank you, Hunter.
This is. We've gone off the rails. We've gone off the rails.
Objection. Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
Your Honor, just you say it in evidence.
The DNA. It's not, right?
It is not. And
Okay.
is there a question?
Yeah.
Yes, it's open. I denied the motion and allowed the line of inquiry.
Wow. So not only is she denying the mistrial, but she's going to let Hank continue to question her on whatever about the dog DNA. Oh, boy. I don't even. I don't know how they're supposed to handle this after, because now, like, what does he do? Get up there on redirect and go through all the reasons why you can't even, I don't know. This trial's like nothing I've ever seen.
Back in session, you may be seated.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was
Oh,
some
that one. Yes.
Remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body breaks, do you have any studies about the frequency or the likelihood of lower body breaks in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide
I'll be right
that
back.
there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it. And I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions. And so therefore there would be reason for either skin cells or DNA or possibly other, parts of, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve. Yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it, excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So yes, I am aware that there were some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion? And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, in giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
Any of the samples, the
found
one
was
sample.
Pig DNA.
That's correct.
And there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog, prove it, John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons.
It's not speculative reason.
So the objection sustained. You can ask it to.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found, there are a number of reasons. If you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA. Yes?
Yes.
You can't tell us anything based in fact.
Mm.
Wait,
No.
I'm sorry.
Sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why, and you want to know, was the test done correctly? Was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well,
I can give you
ideally,
some.
the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scotabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
I can.
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Okay.
He's asking her about that but they didn't follow protocol. He's like, you have no evidence of it, but they didn't follow protocol. Hold on, let me show you something. I found it in my notes. Here, you want evidence it was done wrong? Here you go. Additional swabs can be collected, but only one swab should be handled at a time. Terry Kuhn testified that she did 2 at a time, so she did not follow protocol.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision. I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Okay. Mr. Alessi?
Thank you, Your Honor.
Okay.
He has me so frustrated. I hate the way he behaves. And I hate how misleading he is. Just fight a fair fight. She does question, Kelsey said, is there a reason Elizabeth doesn't question witnesses? She does on some of them. She does a lot of the medical and technical stuff, but Alessi's been doing it lately, but she's behind the scenes doing a ton too.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back, can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces.
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolf, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolf, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction, because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Alessi.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those, and you are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties
So
of the
if we could
authors.
I'm sorry to interrupt you, Dr. Russell.
I'm
You
sorry.
finished?
The specialties of the authors, yes.
If we could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification PPP and QQQ. And I'll start with.
Question mark, question mark, question mark. That's all I'm going to hear when I hear QQQ now. For the rest of my days.
Thank you, Madam Court Reporter. May I present PPP to the, thank you, Your Honor.
Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. DeMunich?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? Do you recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla. And that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite, in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin, and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
Sure. 298.
If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification.
Question mark, question mark, question mark.
Reporter, may I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. And they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the morphology of dog bite injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes,
How is it relevant?
because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting, curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Will, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items, if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay, so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any, is textiles mean clothing?
Yes, and I thought
Was
you
the
meant in this
decedent-
article, but yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt
Please
or
continue.
sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep.
I don't want to
keep on
keep
reading.
reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said.
Thank you.
Yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell.
Mhm.
Madam Court Reporter. So do those studies, the DeMunich and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
So as to the form, Mr. Alessi.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypotheses was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or?
Well, I'd like to give you an example of what you used here in this case as the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong. And so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression. But I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. he asked you several questions, one of which, did you evaluate news clips in audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
What are we thinking? How are we feeling? This is a lot. They've stressed me out this morning. Too much going on. I don't know why she can't explain what she said. I'm curious to hear the arguments on this. Not that a whole lot of their arguments make a lot of sense to me anyway. I feel like some of the way that Hank asks her certain things is he asks it in such a misleading way and makes it sound like something it's not. So then it's like going back over some of those things and having her be able to explain it and give her actual answer without his skewed way of explaining it or questioning it or talking about it or whatever. I feel like that's like, it makes me wonder how much the jury is picking up on different things and what they're putting more weight in, or if they've just like tuned all of this out altogether because they're like, this is too much. Hank gets away with literally everything. Literally everything. It is one of the things that just irks me the most. The way that he can be so disrespectful and there's no consequences about it. And I'm sure that, you know what? I'm sure that there are probably some people who think that he's fantastic. I am just not one of those people. Like at all. Let's do a poll. But at least I got buffalo chicken rollers now. Chat Daddy for the win. Do you think the jurors... Here, let's do it like this. start our poll. These things are amazing. I did not see a post about Kolakithis. About what specifically? About what she's going to say? Let's see here. She had good things to say last year. I'll look it up. Turtle Boy says, FYI, sources are reporting to me that Karina Kolakithis, a witness for the Commonwealth last trial, will testify with a lawyer present that Jennifer McCabe told her that there was Ring video camera footage of John O'Keefe being hit by a car in an attempt to convince her to turn against Karen. This is completely in line with the McCabe's manipulative behavior toward many other witnesses in the days after O'Keefe's death. That would be brand new information. Trying to see what juror reactions I can find. Let's see. Not a whole lot of juror reactions. Let's see. Brennan was just asking if the broken taillight could cause abrasions. Oh, that was back when Brennan. Yeah, that was 38 minutes ago. That's the last juror reaction. Oh, but it's a good one. Brennan was asking if the broken taillight could cause abrasions on an arm. And Dr. Russell said that the pattern of abrasions could not come from that. One juror nodded in agreement. That's all I see right now. If there's anybody else, because they swap every week on who's in there. So I follow all of them who have been in there a lot, but
May I have a moment, Your Honor?
yes.
Thank you.
If I miss any of them, y'all can let me know. I can add them to my list of ones to stalk while we're watching.
Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his that would be toward the back of that slide presentation, probably around 130-ish. That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your honor's permission, show where the radius and where the ulnar bones are of the arm? Lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here. What is the likelihood of there being any fracture to any bone?
Yes.
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe that there is a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, Did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scortabello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scortabello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her for lunch?
All right, jurors, I'm going to send you out for lunch. Okay, we'll see you at 2 o'clock. Yes, come on up.
What are we thinking? How are we feeling? Luncheon recess. I'm exhausted. Like that, exhausted is the perfect word. This has been one of these days. She's sending them to lunch. We'll see if they're about to stay on the record and make any arguments. Oh, and chicken rollers now. They're so good. He brought me 3 of them. So good. Lawyers are arguing at a, or lawyers are lawyers are going to argue at a sidebar while the jury's sent to lunch. I'm assuming that's what they're doing now. Say the third, right? We need a real trip to the beach after today, right? Why can't we watch sidebars? They have them sealed. So there's things that they talk about that they don't want on the record. So the sidebars do generally go on the record after the trial, like in the transcripts. But in this case, they keep them, they've filed to keep them sealed, I believe. So. I can't believe they didn't x-ray him during the autopsy. I believe they did x-ray him, but just not everywhere. They didn't do x-rays of the hands or arms or whatever it was, I think is what they said. But they did do x-rays. We saw the report where it said that he had like the fractured ribs and stuff like that, but that's more than likely from the CPR, because that's common. It's like it's right in the spot where they normally break when you're doing CPR. As soon as they come back on record, I just want to make sure that we don't miss anything else. Do you think Dr. Summeridge will testify? I guess not. They didn't call her in the case in chief, because in the prosecution's case in chief, I don't know if the defense would call her. I don't know. I think Lucky is there today, and then Dighton officer Barros is there today. So, the new motions were from yesterday, but yeah, we can go over those when I come back in a minute. I doubt they're going to do anything but come back and then say we're breaking, but we'll wait just in case. Did anyone figure out the missing witness? It's a missing witness instruction that they're asking for Proctor. The missing witness instruction is for the jury to have, and it's at the judge's discretion, which means she probably won't do it, but it's a party's failure to call a witness that should have been in their case in chief. You can basically, we pulled it up yesterday and I read it, but it was basically like the judge can say something about, like there's this witness like Proctor who should have been called in their case in chief and wasn't, and ain't that suspicious. I'll read it all when we come back.
All right, Chrissy, does that help?
What? All right.
All righty. That's it. That's it. Don't be suspicious. Don't be suspicious. All right. So we're going to lunch. Of course, I am going to give you, they didn't say how long, did they? I don't know. We'll see. I'm going to be sitting here at my desk working for the whole lunch anyway, so I'll be watching. But I am going to give you our Diddy update. I will put this on, and then I'll give you Beach Cam when it's over for the remainder of break. But Lauren Conlin is going to give you the Diddy update. Hold on, let me mute that, so I don't have to hear that static. She'll give you the Diddy update. Oh, she said till 2. Perfect. I'm glad y'all hear it, because my brain at this point, I just can't. So I'm glad that y'all heard too, because I totally missed it. I am going to give y'all our very own Lauren Conlin to give you an update on United States versus Sean Diddy Combs. Her little Diddy bitty recap about everything. And warning, this is one of those cases that talks about abuse and sexual misconduct because it's a wild one. So warning on that. I'm going to put this up just in case for anybody that pops in. I will see y'all in just a few minutes.
Hi, Crime Junkie Jury. I'm Lauren Conlin, and this is your daily Diddy Digest. We are on day 14 of the United States versus Sean Combs, and I'm going to tell you everything that happened in court today. And by the way, just off the top of my head, I made eye contact with Diddy today in court during just a sidebar. I looked away just immediately, but he locked eyes with me. And there, for whatever reason, some of the press didn't come back right away after lunch. And it was kind of after lunch, I guess, maybe 30 minutes. So there was like this open space in front of me. So when he turned around, he just was kind of looking at the clock. The clock was behind me, and then he made eye contact with me, and I was like, "Ooh." And I looked away. But anyway, okay. So we finished the cross-examination and the redirect of Mia, Diddy's former personal assistant and marketing, or I'm sorry, she was the director of development at Revolt TV. And there was no recross, thank goodness, because it was getting a little bit tedious, the cross-examination by Brian Steele. And it got a little spicy, and I'll get into that. But he started off by talking about Mia's resume, and we saw her resume on the screen, the one that she used to get the job at Bad Boy to become a personal assistant. And he just highlighted some things that said that she was used to, quote, round the clock personal and professional needs because she previously worked for Mike Myers. He highlighted a section where she said she had thick skin, and also a part where she said that she collected personal items from Mike Myers and managed those personal items like driver's licenses, his passport, etc. And this caused Brian Steele to bring up an incident that she discussed during her direct examination, which was she was in St. Bart's with Diddy and he had screamed at her and humiliated her for not counting money fast enough. And she testified that, she wanted to leave. She wanted to leave St. Bart's, but she couldn't because someone on Diddy's team had her passport. And during the direct examination, they kind of made it seem like somebody was holding her passport on purpose so she couldn't leave. But this gave Brian Steele an opportunity to say, well, so this is normal. People hold on to people's passports and licenses and or birth certificates within these companies. So that's what someone was doing for you when you were in St. Bart's. So then we moved on to text messages from Mia to Diddy. And we were reminded that she officially stopped working for him in 2017. The texts that we saw were from 2018, 2019, and 2020. Now, one of the texts from January of 2019 really stuck in my head. She wrote this text to Diddy saying that she was thinking of him because she had a nightmare that she was trapped in an elevator with R. Kelly, and Diddy was the one that came to save her. And then she sent another text we saw in March of 2019 saying that she's sending him all the love in the world. Previously, we saw a text from Christmas of 2018 and then also New Year's of 2019 of her saying, Happy New Year's, I love you so much, calling him an inspiration, all of these things. And Brian Steele would say, well, Mia, who is making you send these text messages? You don't work for him anymore. And she just said, I just was kind of keeping the peace, so to speak. And then we saw a text message where she recommends that he should watch a show on Netflix in March of 2019. And then again, sending more love. And there was another text from May of 2020 that was actually, first there was a May of 2020 text where she texted him about Andre Harrell's passing. And it was a really big paragraph saying how much she loved Diddy and how amazing he was. And Harrell would be so proud. And it was, she said he was going through a hard time. This is why I texted him. Same with when Chadwick Boseman died. She texted him in August of 2020. And this kind of opened a little bit of, gossip in the courtroom because she named some celebrities in this text. And again, this is August of 2020. So they have this correspondence about something that they were doing, or something they were doing that pertained to Chadwick Boseman at this certain time period that she's referring to. And, Diddy had said, oh, do you have a recording of whatever they were talking about in this text message after she said she was sorry about Chadwick Boseman? And then Mia says, yeah, it's on one of my computers somewhere. And then she just starts reminiscing about some time they had, but she actually said, oh, remember when Mick Jagger was chasing me and I had to run to get away from him type of thing? I'm paraphrasing. And then she talked about how Diddy called Leonardo DiCaprio that Titanic mother effer when they were somewhere together and they were both gambling and Diddy won more money than he did or something like that. But just to hear him say, oh, that Titanic mother effer, or according to Mia, he said that, we were all like, okay. But again, just showing that they had this back and forth, this rapport years after Mia left the company. And again, Brian Steele would just point out, no one was making you do this. You were texting him because you were friends and you loved him. And yeah, we had text messages actually up until 2023, Christmas of 2023. So I thought that was really interesting, and the jury seemed to think so as well. They were paying very close attention, and somebody had reported last week, I think it was someone on YouTube, that one of the jurors were smirking or laughing during Brian Steele's cross. I didn't see that. I saw some jurors laughing Friday and today during some sidebars, which technically I guess are during the cross, but nothing when Brian Steele was questioning Mia, if that makes sense. Okay, so then I'm sorry, he starts bringing up the Me Too movement. And Mia had stated during direct that she didn't come forward initially because, the Me Too movement kind of gave her courage. She said, back, and I think I've said this, back when she was posting all the time on Instagram in 2012, 2013, it was more about like, how great is your life? Let's all just pretend that our life is so great. So Brian Steele is pointing out that these text messages, 2017, 2018, 2019, 2020, etc., Me Too was already a thing. So why was she holding on to this secret that he allegedly sexually assaulted her? And not only that, she's texting him and still telling him that she loves him. So he was just saying, well, Me Too was a thing. Why didn't you tell anyone at that point? And she said, I was brainwashed. And he's like, brainwashed? Is that your answer? And she's like, yeah. And then he kind of was like, well, what does it mean to be brainwashed? And then she went back into the whole, the highs are high, the lows are low. It was a, quote, very confusing time. And then another text message that she sent to him about, it was July of 2022. I think there was a Bad Boy doc that came out, and she said, oh, I saw our doc in the top 10s on Netflix. Congrats, miss you. He writes back, love, love, love. And then she writes back, again, July of 2022, she writes back, I love, love, love you. And Brian Steele also said, one of Mia's answers, and I think I mentioned this on Friday, she said, you should refer to the experts. I'm not an expert, but this is what survivors do. This is what victims do. And Brian Steele actually said, you keep referring to the experts, but how do you feel about this? Objection. And it was something about the form of the questioning. So speaking of the form, okay. So we took a morning recess, and this was right after a sidebar based on Brian Steele's cross, because there were a lot of objections, and it was mainly around improper form of questioning. So, we were going to come back, I think, rather quickly, but then the government said, Your Honor, if I may, and this is what Mia wasn't there, the jury wasn't there, of course, but Maureen Comey said that she's like, I just want to put it on the record because I don't think the transcript is going to reflect what we are seeing in this courtroom. But Mr. Steele is yelling at this witness. He is being, hostile. He's humiliating her. And because of the way she's being treated, this is going to affect other cases down the line, because other victims are not going to want to come forward after they hear about how Mia has been treated on the stand. She brought up the fact that, Brian Steele was adding his own, what did she say exactly? She said something like that he was adding his own commentary, and he would say things like, let me figure this out, or let me, which I don't think was bad. He was kind of just like reiterating certain things. But anyway, when the judge spoke up, the judge just said, look, I actually haven't heard Mr. Steele yell or get loud with the witness. I haven't seen him be too hostile. It's a cross-examination. So he was kind of giving him some flexibility. But one thing he said was, what I am seeing, and I don't know if this is on purpose or not, but when it comes to the form of the questions, when he is asked to rephrase the question or ask it differently, he doesn't really make the proper changes. And he said, I'm not sure if he's doing it on purpose, just so the jury kind of hears what he's trying to say, But Mr. Steele, if you're in here and Mr. Steele was sitting and he's like, yeah, I'm right here. He's like, that has to stop. You need to fix the form. And he just said, look, the government, you can continue on with your objections and I will sustain. And that's what they did. So when they came back after this, that's when it got I thought it got really brutal, because we had objections for every single question. And Brian Steele could only rephrase them so quickly and so fluently for Mia to understand that, he was having trouble, because after the second or third time of him trying to rephrase an improper question, the judge would be like, okay, now it's time to move along because you're not getting it done. And then another point, Mia would she would repeat his question as though she was trying to understand it. And I understood some of them. I was like, ooh, that sounded like he just said some kind of double negative. That was tough. But other ones, I was like, okay, well, that was a little obvious. So what's going on? But needless to say, it felt like a very long time for the cross. I just want to make sure he showed us a video of Mia wishing Diddy a happy birthday in 2013. I'm just trying to make sure I get everything out there. Oh, he discussed the fact that she had testified that she didn't really get to see her family and friends too much because her life was Sean Combs. And he wanted to get these photos from her social media into evidence where she was at baby showers, weddings, hanging out with family during holidays, so he could show that she did have time with family. Why didn't she say anything? And the judge did not want that to be admitted into evidence and said he could just ask her instead. And then he got into Cassie, Brian Steele, and they spent a significant amount of time on Cassie's career, highlighting all the things that Diddy did for Cassie. He hooked her up with this artist, with that artist. She did movies, she did modeling. Wouldn't you agree that Mr. Combs spent way more money on Cassie than he did on other bad boy artists, or more money went towards Cassie's marketing or her career? And Mia said, I don't know. And then he showed her an email that we did not see to refresh her memory. And this was between somebody in budgeting at Bad Boy and her and a few other people. They were talking about Cassie and something about that she was doing some project. And Mia just said, look, I get a lot of emails. This doesn't refresh my memory in terms of budgeting, but he hinted that Diddy spent more on Cassie than other artists. And we had heard that before as well. And then he said, do you remember telling Cassie, sticking up for Diddy, saying, oh, well, he only lashes out at people he loves. Do you remember comparing him to a toddler having a tantrum? And she said, yeah, I mean, this was my job at the time, essentially, to kind of, placate him. I was his employee. So yes, although Cassie, I was very close with her and she was like my sister, unfortunately, I had to sort of say these things to mitigate the situation. And, he seemed to bring this up a lot. This was your sister and you still texted Sean Combs that you love him, even though he pile drove her head into a bed and sexually assaulted you. Oh, and then Brian Steele also made this comment, he said, you've mentioned that the highs are high and the lows are low, but how do you make an excuse for sexual assault when it comes to the lows being low? How do you even compartmentalize that there? Sexual assault is this whole different beast. And again, objection. So she didn't get to answer. But yeah, that was pretty much the extent of it. Oh, just kidding. The last thing they focused on was her meetings with the government. She had about 27, and it was revealed that she did not share that she was allegedly sexually assaulted until her third meeting. And Mia said, I didn't disclose that I was sexually assaulted until I had a lawyer present. And Brian Steele said, okay, well, you had a lawyer present at your March 2024 meeting, but you didn't tell the government about being allegedly sexually assaulted until the June of 2024 meeting. And she said, okay. And then he tried really hard to get in the fact that she was using Sean Crowley as an attorney who had just had this big settlement, but there was an objection. And so he could not. And also there were two occasions where he tried to talk about Mia's therapy notes and how she waived her privilege to try to get these in somehow. And there was objections both times. And then they had a sidebar, and the judge told the jury to disregard any questioning about the therapy notes. So yes. Okay. So that is, I guess I could say he brought up the slamming of the door in her arm when Diddy stole her phone. He also brought up she and Cassie paddleboarding away in Turks and Caicos, kind of hinting like, you know, did this stuff actually happen? Did you take a photo of your arm? Did anybody hear you scream? Because that sounds really painful if someone's slamming your arm in a door. You know, she said no. She said she kind of blacked out. With the paddle boards, you know, he asked, did you tell anyone this happened? Did you text a picture to anyone? She said no. Again, just hinting that maybe this stuff didn't happen. And okay, that really was the extent of the cross. Now I'm finished. So redirect, it was pretty standard, pretty simple, but the government just asked her essentially about the birthday post. Like, you texted Diddy on his birthday and you did all these posts for him on his birthday because you were his employee and you were expected to. And if you didn't, that will be weird, right? And she said, yeah, like if I was the only employee not posting on my personal account for his birthday, that would be strange. She said she basically felt like she had to. And then they reiterated, well, wasn't it part of your job for your personal life and your personal Instagram to kind of partner a bit with posts and things that Diddy was doing, like Ciroc, or the, you know, there was something that she posted about the Diddy door or the Bad Boy reunion tour. She just said, yeah, this was part of my job to post these. So yes, it bled over into my personal life. Oh, and then, sorry, I did leave this part out. Sorry, with the cross-examination, because it's important. It's very important. Brian Steele elicited from Mia that she worked for Madonna after Diddy for about 8 months, saying like, so he didn't blacklist you from the industry like you thought, type of thing. And she just said, you know, well, he didn't help me get the job either. So, but they did, again, during redirect, go through that, yes, she had PTSD, and she really only worked for Madonna. It was a contracted time period. She said she was supposed to do 3 months, ended up doing 8 months, and then it was done. Yeah, that was pretty much it for the redirect. Again, just reminding us that she was in a very complicated situation. And she came forward when she felt comfortable, when she had therapy. And they said, you know, why do you want to be here? Why do you want to testify? Because they made sure that we all knew she wasn't getting any money out of this. Oh, and they also brought up that when she met with the government very recently, she was using a pro bono lawyer. So it wasn't any type of big shot civil attorney money grab type of thing. Oh yeah. And during the redirect, she also stated that someone named Kayla, a personal assistant, was fired for discussing Cassie's abuse. And when this happened, Diddy said to her, you know, you're going to have to testify against her in court one day. And also said the same thing about Capricorn Clark when she left. I don't know what he's talking about, testify, but Mia said that he said that to her, which again was one of the reasons that she never told anyone about Cassie being abused or about herself being abused. And yes, at the end, they said, why are you testifying today? And she kind of got emotional and said, I just couldn't look my niece or goddaughters in the eyes again if I didn't, something along those lines. So then we were done with Mia, no recross. I think everybody was very happy to just get Mia moving along. And overall, I would say her demeanor on the stand, she generally has a positive vibe, I think, and she was happy to answer the questions. You know, she had a good attitude about it. My only time was I was like, I wonder if she is repeating some of these questions, if she truly doesn't understand it, or if she's kind of giving Steele a taste of his own medicine. Okay, so then we moved on to the last witness of the day, Sylvia Oken, who is an employee of the Beverly Hills Hotel. She's been there for 17 years. She's currently the director of sales and marketing, and she previously focused on their, quote, entertainment clients. So we saw profiles, we saw invoices, and essentially the purpose of her testimony was to show that Diddy booked rooms under an alias. it was Philip Pines and Frank Black. And then we saw a profile that had Cassie's name as one of the people that would frequent the hotels with him. And then we saw some bills that had a miscellaneous charge for $500 for oil damage, corroborating what we've heard before with the hotel rooms. And then a $300 charge on a separate bill for a deep clean of the drapes for $300. And during Tenny Garagos did a very quick cross-examination where she just said, listen, it's not weird for celebrities to use aliases like the Frank Black or Philip Pines. And Sylvia Oaken's like, nope, totally normal. And then she just said, also, you don't need to have everybody's name on the room that comes and goes through, to the hotel room, right? Like just one is fine. And she's like, yeah, just one, but we don't know who's in the hotel room. And then Tenny Garagos kind of focused in on one area where there were two names. It was Cassie Ventura and Dominique Neal. And then she said, oh yeah, there's two names basically. And then Tenny said no further questions. So we were kind of left with that. Now what we have on the docket for this week, by Wednesday or Thursday, we are going to hear from what I think is the last and final victim, Jane, because I believe that victim Gina is not coming from what we had heard at the beginning of the trial because she could not be reached and her attorneys could not be reached. They also talked about one of Cassie's friends testifying, Bana or Brianna, and then someone named Eddie Garcia who will be testifying tomorrow. I believe he is somebody that worked at the Intercontinental Hotel that was there for the beatdown in 2016. He did get sworn in this morning and he has been granted immunity. So I'm thinking that maybe this is pure speculation. Perhaps he was offered some money by Diddy and he took it, so he needs immunity. Who knows? We will find out. But anyway, all right. That's your almost 23-minute daily Diddy Digest. I'm Lauren Conlin. Thank you for watching, and I will see you for her next update tomorrow.
Hello, jurors. How did I scare you? I literally warned you. I start moving stuff on the screen. I come back. I move stuff on the screen again. I put my camera on, give you a minute. Then I unmute my mic and then I say, psst, and I still scare y'all. Y'all be terrible at scary movies. You had me at psst. Matthew Moore says, girl, you scary. I've been told that before. I love that. Psst. Don't be a Hank. Sandra Parker, I love it. I'm going to end our poll. In a world full of Dr. Hanks, be a Dr. Russell. Or a world full of Hanks, be a Dr. Russell. Yeah. Poor Dr. Russell. Dr. Russell's like, I did not want to be involved in this. I reluctantly agreed. I bet she's regretting that now. Because they have been awful to her. They're coming back, but I can give you real quick the defendant's motion to present a missing witness argument. I've got the documents I pulled. It's appropriate for the court to give a missing witness instruction where a party has knowledge of a person who can be located and brought forward, who is friendly to or at least not hostile or hostily deposed toward the party, and who can be expected to give testimony of distinct importance to the case. That party would naturally offer that person as a witness, as in like they should be calling this person
Back in session, you may be
Proctor.
seated.
And if they don't, the jury can infer that the witness would have given testimony unfavorable to the prosecution.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities. And to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee. And I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
No further questions at this time, Your Honor.
Oh, okay. Brennan?
Could I inquire about scope?
See what's that on.
Ugh. That wasn't long at all. I'm like already trying to. Breathe in. Release the hank. Breathe in the fresh air. Blow out that blowhard. Okay. And his new hair looks stupid. Last one, promise. Okay, be good. Is that me typing loudly? I am not typing. And I have one of the silent keyboards. You can barely hear mine when I do it. Andrea thinks Hank is extra rude, so defense won't call many people to testify. He comes across to me. It is my opinion, to a reasonable degree of podcaster certainty, that he is very calculated and a total trying to make myself be nice. It is my opinion, to a reasonable degree of podcaster certainty, that he is very calculated in how he does things. And he is very manipulative of people and situations and evidence. I am not a fan. He is one of those that I think I could handle in a short trial. But we've been at this for too many days, because we are at day 26 of the trial, plus all of those pretrial hearings. I am ready to rehome Hank. I can't deal with him. I said the same thing. Like I think I said that like a couple weeks ago, whatever. Like he is such a gaslighter. They're talking right now about he wants to inquire about the scalp. Hold on. I'm live. Do you need something? Are you okay? What's wrong?
May I?
Yes.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Alessi had you look at a couple of case files from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question. So we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alessi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alessi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Can we have Exhibit 1, please? Now, regarding the Munich article, that was a case study on the unfortunate death of a young girl, yes?
Yes,
Who was attacked by or bitten by up to 3 different dogs.
yes,
And it was a neck wound from which she bled.
yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you
No.
if it is different.
Oh, it is different.
Very different, isn't
Yes, that neck wound, yes.
it? Extraordinarily different.
Yes,
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
yes,
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
yes,
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. The way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see one or two things that shown up what I think might be upper and lower, so it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert.
Oh, God.
So when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity. I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone, on that wound.
There are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is, it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However, I'm
just asking you the question, Dr. Russell.
So you can maybe ask.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alessi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the, no, I don't agree.
I move to introduce this as an exhibit, please.
Mr. Alessi?
210.
He's so aggressive and rude. I can't even, it's hard to even listen to him. Even if like at this point, it's so bad that even if he's making a good point, I won't hear it because he's just so obnoxious.
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do
Do you
that.
see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on
Oh,
what you're
God,
portraying as
I
facts
can't.
to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor, so in the ER, I've treated thousands of motor vehicle accident cases, and most of the time I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alessi, and that's why I'm pressing you on these issues. Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about with these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event.
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr. Brennan,
Is that true?
I have no details about the collision?
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have any details that you know of other than what was told to you, correct?
That's all they damn have. You
There
moron.
are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise. It depends on the location. It depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and the or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard on the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
Objection, Your Honor.
The objection system.
Thank you.
When you came to your conclusion, considering what you see in this picture, and Attorney Alessi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor.
Sustained.
Finally, Dr. Russell, you said during your differential diagnosis, you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor.
I'm going to allow that.
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the
Oh
extent
my
of his authority
gosh.
before you know anything? Why is that important?
Objection.
Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes the report in terms of physicians and what their possible experiences are. Do they work in a medical examiner's office in Alaska or Hawaii or big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the Demunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of Attorney Brennan asked you, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article?
Hold on. I want to give you a quick update. You know how when she was just answering that last question that Brennan asked, we could tell like he wasn't standing at the mic when he said that's all he had or whatever? Let me tell you why. He asked her that question, and as she starts answering, he completely disrespects her, completely disregards her. As she's still talking, he walks to his seat and sits down in his chair while she's still talking.
About whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin. And there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had.
Yes, thank you. So may I hand it to the witness?
Yes.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little
Yes.
bit.
Yep. Dr. Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw it.
Commentary, I'd like to be heard.
Why don't you bring the reports over?
He's really one to talk about objecting to the commentary. I just have zero respect for him. I have none at all. Think about how disrespectful that is to ask her a question, and while she's talking, just walk to your chair and sit down. He's a child. The defense does object, but I mean, they can only do so much, and Bev allows it. She doesn't. She lets him just basically do whatever. It is so frustrating to watch. It is so frustrating. I just don't understand it. I don't understand how you can. Like it literally has me like so frustrated. Like he's hard to watch. It's hard to watch. It's hard to listen to. As soon as he gets up, I'm already annoyed because I know that he's going to twist things. He's going to be disrespectful. He's going to break all the rules and not care because he knows he's not going to get in trouble for it. And it just, I can't even stand to watch it or listen to him. Sidebar discussions are on record, but they are sealed. For this case, anyway. Jessica Machado just said, I can hear Cannoni, who is speaking loudly. Paul O'Keefe is sitting in front of me, and he noticed as well. Motion to the man sitting on the side of him, who is now also looking at the sidebar.
May I return next to the witness stand, Your Honor?
Yes.
Thank you. May I proceed, Your Honor?
Yes.
Thank you. Dr. Russell, I am re-handing you this letter from Dr. Walsh. And what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
I'm going to have this marked for identification.
Thank you.
R, Freddie.
Thank you. And the next witness is who?
Sorry, Your Honor.
Who's the next witness?
If I may, Your Honor.
Yes, just tell me the name because I need to know whether we need to go to sidebar first.
Officer Barros.
Okay, thank you.
Officer Barros.
So you're gonna step up, face the clerk, and raise your right hand, please.
Mr. Holmes, the evidence you give to the court and jury in the case down here. The truth, the whole truth, and nothing but the truth, so help you God.
I do.
Maybe seated.
Good afternoon. All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barros, Barros,
And where do you currently work?
the town of Dayton, Dayton Police Department,
How long have you worked for the Dayton Police Department, sir?
since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dayton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dayton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the detective bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right. As a sergeant with the Dayton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Did you know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dayton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual?
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to location?
Yes.
I like his suit.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dayton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger.
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barros, did you, I don't want the address, cameras are rolling. Did you respond specifically to a residence in the city of Dayton?
Yes.
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dayton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon, he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dayton to retrieve a vehicle that occurred at a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow, to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitated tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes. Once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there. And I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between, longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that description is?
There was, it was damaged. The taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight?
Woo!
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Oh, oops.
Sergeant
hold on.
Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
Woo!
What's different about this photo, sir?
That taillight is completely smashed out.
Whew.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Yeah. Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically.
Middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way. The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
We can take this down. As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have.
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen? Like, for instance, the SUV is taken away?
When I clear from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is Diamond Towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area. This area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? And you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please. Thank you. Mr. Brennan?
Thank you.
Oh, boy. Brennan's going to be really aggressive.
Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
You ain't missing
Do
nothing.
you still work in Dayton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene
Yes.
because it's your jurisdiction.
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it.
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you, you introduced yourself to them, they went into the Reed house,
Yes.
and then they came out.
They came out much later.
And that vehicle was towed.
Correct.
At no time from when you got there until you left, did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dayton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at the moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
I did.
Inevitably, you were a witness at trial. You were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations, which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
What were you asked about to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Were you asked questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed.
Time has passed, yep.
That you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed.
Correct.
That your report was respectfully scant.
Correct.
But you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, is the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel to speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel?
Jackson doesn't have an office
Boston.
there.
And
So
where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end.
The
The good-looking one down there on the right.
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came to the court?
No.
The photograph of the vehicle in the Sally Port, the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen in Dayton.
Nobody asked me that.
When you were asked to describe the damage and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged. It was cracked, and there was a piece missing, but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
is that better?
So in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
They didn't show him the picture. He's tripping him up here because he's
Have
talking.
you ever read your testimony from your last proceeding?
He said that
But you have a specific memory of discussing that specific photograph.
it was
Yes?
cracked and
Yes.
but not completely damaged. They didn't show the picture.
Any approach?
Yes.
So he's going to try to use that to.
I'm going to show you
Discredit him.
your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right?
Objection.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And as you take a look at there, could you show me anywhere in your testimony? Anywhere. Where you made any statement about that photo being inconsistent with what you saw in Dayton on January 29th, 2022.
He said it was cracked, but not completely broken. But they didn't ask him if it was different. But that's the thing is, he said that he put it in his report too. His testimony has never changed. It's never changed from the beginning. From the very beginning, he said it was cracked and not completely broken. He wasn't shown the. They didn't do a cross-examination of him last year because they were like, "Well, he said exactly what we needed him, like, you know, to say." He said what was in his report.
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why the academy, they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade, right?
Correct.
Memories can change.
His never has. His has never.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath, you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah, correct.
And you share those same difficulties with memory as many other witnesses.
Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, you're to say that never happened.
Correct.
You were simply mistaken, weren't you?
He's trying
Or
to.
something more, please tell me.
Correct.
Not remembering saying it during the last trial when you've said it different times or whatever is not a big thing. He remembers what
When
he
you
told
met
me,
with
very
the
specific time, and
attorneys
it's
in
never
Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Oh,
Could have.
Come
So
on,
the
Brennan.
face-to-face meeting, what did you talk about?
Come on, Brennan.
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay?
He did not just say over here, did he? Hold on, because he's asking him, and it looked like he was looking over at Jackson as Jackson was objecting, and Brennan was like, over here. Listen.
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay?
Over here.
What he's doing, this is Hank's tactic, other than being rude and disrespectful and childish and ridiculous and obnoxious. He wants the jury, it's like he keeps pointing to the defense, like trying to make them look shady and secretive and stuff like that. Like the whole thing about the highlighter. Dr. Russell didn't have a highlighter. So she was like, this is what I need highlighted. And he highlighted that. And he makes it into a big deal. Asking about meeting. Everybody meets with a witness. This is not a big deal. He's trying to make it look to the jury like the defense is doing everything shady. Because he does shady stuff. So
You told us there was some background about being subpoenaed and time. Substantively, what did you talk about with the attorneys when we met them at their hotel conference?
Other than that, they didn't go over my testimony. We just spoke about that. I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably June. Early in this year.
Are you having some difficulty with memory about that?
Oh, come on.
On a certain date, yes.
Not a certain date. Was it this year probably? Do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? Yes. No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV. And
was it shown to you during your conference room meeting at the hotel?
It was not.
So you've looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case since you made those observations indicted on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory?
Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay.
The last sidebar, when he was so rude. We'll go back and look at it in a minute.
You've seen quite a bit of information about this case and the issue regarding the taillights since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
His memory has never changed. He's never changed anything he
I guess.
said. He's never changed anything he said.
That you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it indictment. If we could have the ring video at 5:07:58, please.
The condescending, like, placating. Oh, I can't. He's trying to equate him forgetting that he didn't point to the picture in the last trial as him not knowing anything
Have you
about
seen this
what
video
he
before,
saw.
sir?
I have.
Before you proceed, Ms. Gilman, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look to compare to your memory?
Did I have a
Yes.
particular interest? No, I didn't. I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. Who's playing this with? Turn the sound down. Thank you. Stop, please. Do you see that white part of the back rear right taillight?
Objection.
I'm going to allow it.
You see that? Sir?
Can you zoom in a little bit more? I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop it. Can you bring it back, Ms. Stone? Back more. Open, right there. Zoom, please. You see, sir? Sorry?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day.
Yes,
And when you got to the driveway, it had not been shoveled or plowed.
correct.
There was quite a bit of snow accumulating and ongoing.
Yes,
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes,
When you looked at this house, when you looked at the defendant's Lexus in Dayton, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
We have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dayton? Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear taillight and the missing parts there, is that consistent with what you saw around 3:27 on January 29th?
Nobody seems to agree on that one picture. Everybody.
Yes.
Everybody.
Have no further
that a
questions.
lot because of the.
Okay. Lights on, please, Mr.
No,
Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain us to the form, Mr. Jackson, is
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dayton, correct? Being called out to Dayton to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that? Right?
Mm-hmm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dayton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD? I'm sorry, in Canton, in the Sally Port at the police station?
I wasn't.
At 5:30 p.m.?
Objection.
Sustained.
At any point, did you ever go to the Sally Port at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sally Port?
Objection.
Sustained.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
Objection. Move to strike.
So that's stricken. It's beyond the scope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken, correct?
Objection.
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Objection.
Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barros, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
Thank you. That's all.
You would agree that your memory has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I think it's
We'll
hard to,
allow it.
I think it's
opened
hard
up.
to,
It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set. sir.
Thank you.
Quiet, please.
All right, so jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing out witnesses. So those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day, we'll finish by 1.
Oh, tomorrow's a half a day.
All rise to the court, please. And those in notebooks, follow me.
Let's see what the attorneys say on record. Also, we're going to go back and look at before one of those sidebars. First of all, both of those sidebars, Hank is out of control at this point. He, Jess Machado said that the one lady who dated.
Jurors exit the court, please be seated.
Hold on, we'll talk about it.
So there have been some motions, I think, piling up. 2 I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Giannetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time, I just don't know what you're talking about.
May we approach side
Sure.
I think think about like this, when everybody looks at that one picture in the driveway and everybody argues over what they see, right? Because of the snow and the quality. I get it. Everybody argues over that, about what's taillight, what's snow, what's missing. And I think to show that and compare it to what he's looking at in the in person right there for so long, especially with it being right there on the corner, being able to see what's broken and what's not, I wouldn't be able to do that. So Jess said, I can't believe he just said over here, like called him like a dog. Jess said, Jackson called for a sidebar, and I just saw Brennan smirk at a woman sitting in front of me, which is the one who, never mind. I'll keep my comments to myself. Barros looks over at AJ. Oh, wait, wrong one. Brennan smirked at the woman sitting in front of him, or in front of her, as he approached the bench, and she smiled as she turned to the woman on the side of her and sipped her water. I saw her smiling. We'll go back and look at it in a minute when they come back on record. Oh. The amount of disrespect, it's just wild to me. No, not a juror. This lady. Hank smirked at her and she like smiled back, and then it was weird. No, not a juror, not a juror. Said the woman in front of Jess. Called him like he's a dog. Over here. Ugh. The one who dated him like a couple decades ago or something. I'm like, Today was a lot. Yeah, AJ repeated over here. They said that in the reporter's notes too, that he heard, like, after Brennan said that, AJ was like, over here? Like, really? He's out of control. He is out of control. Who acts like that? I would not. This is why I couldn't be a judge. I'd be like throwing my stapler at him or something. Like, I wouldn't be able to handle it. I would not. I would have to like when my kid was not disrespectful like that. But anytime he did show any kind of disrespect, I'd grab him by the ear, like. Like, I wonder if he's embarrassed or if he's proud of that behavior. I can't. Over here, like he's a dog. Like, have some respect for him. Ugh. So what are we thinking? How are we feeling? Sounds like they're going to be in. I'm going back. This is it.
Okay.
Over here.
This is the one where the reporter said Hank smirked at her. I guess they like how he acted. I'm just staying quiet because I don't have anything nice to say right now. So I'm trying to. Am I the only one here that didn't know about the first trial? Probably. But welcome. If you didn't know about the first trial, I am so curious about what you think about this one. Oh, Angela, you didn't know about the first trial either? I would love to hear y'all's take on this one from somebody who didn't see the first one. Does the defendant usually go up on side bars? Well, it depends because like sometimes they do go up. A lot of times they'll have them like an earpiece so that they can listen in without having to actually go up there. They requested that and Bev didn't do it. So since she couldn't have the earpiece, she goes up there so she can hear it. But she tried to get like a earpiece so you could hear it. If mistrial again, they would be able to try Karen again though, right? So we don't. So don't we want to avoid that? Yes, if there is another mistrial, unless like earlier they did request a mistrial with prejudice, which that would never have happened. But if it's a mistrial is declared with prejudice, then they can't do it again. The case is just thrown out. But if it's like a mistrial, like a hung jury, then that is not dismissed. That means that they will try her again or can try her again. Doesn't necessarily mean they actually will, but it means they can. Double jeopardy only applies if, like, it basically means you can't be convicted of a crime that you've already been acquitted of. So with them going, that's like a very oversimplified. People will cut that and be like, Brandi said this. No, that's a very oversimplified. But I'm saying in this specific situation, if she had been acquitted, like if those juror votes had been read aloud in court from a verdict form and done formally, then those would have been considered acquittals. So she would not have been able to be retried on those because those would be that would be considered double jeopardy. As an example. I'd be going to every sidebar if it was me. Me too. I would want to know everything that's being said. That's your life. Because who knows, you know, a lot of that better than, like, you're going to know so much of. I know I would. I'd pick out every little detail. I want to know everything that's going on. Just say your whole thoughts. Stop this for. I'll tell you why I don't, because I have some that are not necessarily. it's different for me to be able to say fully what I think. It is irresponsible for me to do that because when it comes to, you know, the attorneys and things like that, that's one thing. But when it comes to people, I can have my opinions, but I just am a little bit more guarded with what I say about them. I want to thank you for doing this case for us all. Thank you for being here. I only started watching near the end of the prosecution's case. I've been researching this ever since, so fascinated by it. Initially, my impression was Commonwealth deceit, and as I learn more, I am convinced. Yeah. They already attack you unnecessarily. I get it all the time. I'm used to it. It comes in waves too. It'll get really bad for a while and then it'll calm down again. It's been really bad lately since I found the stuff on Welcher. They're mad about that. So now it comes in waves. It's part of it. Looks like. What happens with a missing witness filing? Can they make Hank call them? For the missing witness thing, basically what it is just giving the jury instructions that, you know, if there's somebody on their list that they should have been calling and they're not calling them, then you can infer that that's for a reason. It's because they would have had, you know, information that's not favorable to the prosecution, and that's why they didn't call them. I also didn't know about the first one, and I actually thought she was guilty based on others' opinions. After watching Every Day with You, thank you. I can't see why you would think she's guilty. You know, my husband saw this thing. It was like the different stages of Karen Reed, like people getting into the Karen Reed trial. And like the first stage is like, you know, oh, what's this? This looks interesting. And then it was like, oh yeah, she's probably guilty. Like she, you know, probably hit him and whatever. And then the next stage is like, wait, they rehomed what? Wait, where are their phones? They threw away their phones on a military base. Wait, how many butt dials? And then the next phase is like, the next phase is like, free Karen Reed, free Karen Reed. It was funny. I was like, that's accurate for a lot of people. Because that's what I thought when I first started. I was like, she probably, like, it makes the most sense. Yeah, a lot of this stuff doesn't make sense, but it makes the most sense that she did, right? Like, that's what I'm thinking about, like, Occam's razor. It's probably got to be. But then, like, the more you look, the more you're like, wait a minute. You can only have so many coincidences without being like, wait a minute. Wait a minute. Their butts make more phone calls in one night than I make intentionally in a month. So I don't know. I don't know. All right. So we are done for the day. It's exhausting. He's exhausting. I'm going to work on finishing the podcast. I know I'm behind. If life has just been nuts. So I'm going to work on finishing the podcast so I can try to get it posted maybe late tonight, early tomorrow morning. And tomorrow is a half day. Oh, I'm excited. Tomorrow's a half day. Hank is exhausting. Listening to his I can't deal with him. I can't deal with him. If you haven't hit like, please do. If you haven't seen, I was on Court TV last night with Vinnie Politan discussing it. The link, I think, is up now on Court TV's website. If y'all want to check that out. And of all people, the one that they had me in my segment, because I'm in the second half of the show, and in my segment, it's me and DePietro. I was like, oh, I know him. He's the one that I thought was a parody account on Twitter. So I thought that was really funny. I was like, when the producer emailed me who I was going to be on there with, I was like, are y'all doing this on purpose? Because I just said I thought he was a parody. It was funny. I saw you holding back on it. My husband noticed I rolled my eyes when he said something. I didn't notice it. I was like, I was focused on fixing my face. I was like, best behavior, Brandi. All right, I need to get to work. So I say get to work like we didn't just finish a whole day of work, but I need to. JD said you called Brennan a master. I called him a lot of things, but anywho, if you haven't hit the like button, please do so. I appreciate y'all hanging out and watching. Today was a wild day. It was a very wild day. I got the recap. Okay. Well, yeah, I'll get the recap done and then try to get the podcast done so that y'all can have recap in a little while and you can have podcast tomorrow morning. So I appreciate y'all hanging out. Hit the like button on your way out and I will see you bright and early in the morning. And thank you for wishing Lucy happy birthday. You want to tell your friends bye because it's your birthday? Come on, you want to tell them bye because it's your birthday? Say bye. Say bye. Say bye to your friends. Say bye. She's so cute, isn't she? I love her. All right, y'all. I will see you in the morning.